Unfortunately, the crypto war continues to rage, and it's looking like it's high time for us in Cardano to decide if we should jump into the battle now or wait until we're forced to be directly involved. Ready? Let's go. Today, we are going to discuss the Coinbase answer to the SEC complaint and whether it means anything for Cardano, a surprising bit of information related to the founder of our biggest competitor chain, some serious questions about smart contract retirements on another competitor chain, and some metaverse news. If you find this image to be inauthentic because you know deep down that Gary Gensler would never wear skinny jeans, or if you're finding value in these videos each weekday, please consider delegating to the Army of Spies stake pool, ticker AOS. At this point, we have to ask a serious question about our biggest competitor chain. Does anyone who actually understands Ethereum staking fully trust Ethereum staking? Because guess who doesn't? The most notable personality in all of Ethereum, Vitalik Buterin, just made a very interesting admission. So in this video, Vitalik says that he only stakes a fairly small portion of his personal Ethereum, which is probably going to surprise a lot of people. That's right. He said, his words, a fairly small portion of his personal Ethereum. And his explanation for why this is the case was kind of muddled and confusing and ambiguous, but he definitely used the word safety, and he used the phrase, it gets complicated in a bunch of ways. And his larger explanation had something to do with the fact that he believes you really need multi-sig, and setting up multi-sig is difficult and it gets complicated in a bunch of ways. But the upshot is, even Vitalik is only staking a fairly small portion of his personal Ethereum. And this isn't really a surprise at all to anyone who's been paying attention, because quite a while ago, we saw this video that Stick with Pride posted here in the comments. And in this video, another Ethereum insider who definitely understands what's going on was asked, how come he doesn't stake all of his Ethereum? He admitted that he stakes less than the average. I think the phrase he used was less than the average. And his explanation was that when you make the sausage, you know how the sausage is made. And then he just kind of laughed. He laughed it off, like that kind of explains it. Hey, if you know how the sausage is made, you're not going to eat the sausage. And that sausage is Ethereum staking. The more I learn about Ethereum staking and the actual staking habits of the people who were sort of inside the process of building Ethereum staking, the happier I am that I'm in Cardano. Here's something else that makes me happy I'm in Cardano. This post says, is this how everything on Solana works? Devs can unwind and literally delete the smart contracts at any time. If so, what is the point? I have to agree. The beauty of smart contracts, at least as they were first presented to us, the crypto ecosystem, part of the beauty was that they're committed to the chain and then they're just there. No one can take them down. They are immutable. That's what I perceived, at least, to be part of the beauty of smart contracts. Apparently not the case on Solana. So the post he's referencing says, at the end of the 2-month notice period, we will forcibly withdraw all remaining deposits and return them to depositor addresses. Among other things, this will include tokens that are still staked, unallocated stake pool rewards, and NFTs wrapped with token managers. At that point, everyone that had assets deposited in any of the contracts will have them back. We will then take down our UIs and remove our smart contract deployments from Solana. In the process of removing the smart contracts, we will return the SOL denominated rent stored in all accounts to the relevant account's initial fee or rent payer. And he follows it up by saying, state rent really changes the dynamic. This is something I didn't even know they had in Solana. Now a protocol team shutting down becomes similar to any failed startup. Smart contracts get retired just like the centralized web servers of any failed startup. That certainly sounds like how it would work with a web, a Web 2.0, a normal tech startup. You just sort of the company retires, and along with it, whatever they've got running on their servers. This post says, yes, I completely agree, but this is not what state rent is. Contracts on Solana need to pay rent in order for nodes to store them. This is to prevent nodes from storing deprecated contracts nobody uses. ETH also has the self-destruct opcode, so it's not like that's not a thing on ETH. I don't know about you guys, but honestly, one of the good things about smart contracts was that they just kind of live forever on the chain. Apparently, there is this thing, state rent in Solana, that creates an incentive for projects to remove the smart contracts because apparently they have to pay the nodes. What does he say? Contracts on Solana need to pay rent in order for nodes to store them. I'm sure they market this as a feature, not a bug, but I would definitely say this is a bug, not a feature. Here was the big news of the day. We finally got to see the Coinbase answer to the SEC complaint. And right off the bat on page 1, you can see that Coinbase hired a couple of white shoe New York firms, Wachtell, Lipton, and Sullivan and Cromwell, as counsel in this litigation. These are exactly the kinds of firms you want representing you if you're going to be in litigation with the SEC, if you can afford them. If you can afford the best firms to be counsel for you in this kind of litigation with the SEC, you want to do it. And it looks like Coinbase, of course, can afford them. So they've gone ahead and done that. That's a very good sign for all of crypto. So what is an answer to a complaint when you're in litigation with the SEC? So what's going to happen first is Coinbase is going to go through and sort of tell their version of the story. In the SEC complaint, they sort of told their version of, what a bad securities violator Coinbase is. Coinbase is going to go through and they're going to tell their version of the story. And, they say the kinds of things you think they're going to say. They're, saying, hey, we're not a securities broker. Hey, you approved our registration statement. Back when we went public, our business hasn't really changed since then. They're going to say all those kinds of things. Maybe most importantly, they say this. This is maybe most pertinent for all of us in the ecosystems of the coins that the SEC, named as securities. On page 33, paragraph 82, the SEC's claims lack all merit. Its still evolving legal position rests on a novel, atextual, that's not textual, and acontextual, so not textual or contextual, construction of the word investment contract in the federal securities statutes that runs directly contrary to SEC officials' public admissions about the limits of their agency's statutory authority. So, of course, we've got that laundry list of securities in the Securities Act. So one of the words in that laundry list of things that are securities is investment contract. And that's what the entire Howey case is about and the cases that followed it. It's about what is an investment contract. And here Coinbase is basically saying, hey, you're saying that crypto assets are investment contracts, but this is a novel legal position. This is a brand new legal position that lacks any text in the statute to support that, and it lacks any context that supports that either. Here's where it gets really interesting. They also say, even were the proffered construction colorable. So they're saying, even if this is, a legitimate claim in any way, if this construction of the phrase investment contract is colorable in any way as proffered, the major questions doctrine would counsel against its adoption by this court and in favor of deference to the Congress's legislative prerogative. So we're going to talk about that a little bit later, but this has to do with Coinbase making an argument about the major questions doctrine that was central to a case the Supreme Court heard last year. That would have been West Virginia versus EPA. So we'll talk about that in a little bit, but it's sort of a contrasting position from the Chevron deference doctrine. And we'll talk about what those two things mean. If we come down here to page 35, Come out down here to page 35. We see this interesting line. Coinbase denies that any of the assets it makes available on its platform include crypto asset securities, that it has deprived anyone of required disclosures or protections, and that it has exposed anyone to significant risk. Coinbase otherwise denies all the allegations in paragraph 1, and all the things in paragraph 1 was Coinbase is never registered with the SEC as a broker, a national securities exchange, or clearing agency, thus evading the disclosure regime that Coinbase has established for our security, or that Congress has established for our securities markets, all those kinds of things. So this is a necessary denial for Coinbase to make. Central to the SEC's claims is that all these crypto assets that they named, at least the ones they named, and they would say, of course, a whole bunch of other ones, like all of the rest of them, with maybe 1 or 2 exceptions, are all securities. So Coinbase has to deny that any of those assets the SEC named are securities. That includes ADA, the base layer token of Cardano, importantly for us. This is kind of a great position to be in as Cardano people. We have Coinbase, one of the most well-heeled entities in all of crypto. They're sort of required to argue for us that we are not security. So speaking of ADA, if we go down here to the actual ADA section, so you remember in the SEC complaint, they of course addressed all of the coins and tokens they named, including ADA. So if we come down here to this section, you'll see that this is the section where they address a lot of questions of fact about these different tokens. So in litigation like this, we've got two big categories of things. We've got questions of law and questions of fact. And the very, very interesting part probably is going to be the resolution of the questions of law. And we'll talk about that very specific one, major questions doctrine versus Chevron deference, in just a second. But in this section, they're going to go through a bunch of questions of fact. And this is just the answer. As far as a lot of these questions of fact involving these individual tokens, this is just sort of the place where they set the parameters of this adversarial engagement. What are they going to fight over? You'll find in this section that Coinbase admits a lot of stuff. These are uncontested facts. Coinbase admits that Cardano represents that ADA is the native token of the Cardano blockchain, which blockchain was created in 2015 by Messrs. Hoskinson and Wood. Uncontested facts, they're just going to admit it. Some other things they're going to deny. Some other things they're going to say Coinbase lacks knowledge or information sufficient to form a belief as to the truth of any remaining allegations in that paragraph, and therefore denies them on that basis. So they're saying, hey, we don't have the requisite information or knowledge to know if what you said is true or not. So we're going to deny it for now until we're able to do discovery. So discovery is going to be this process where they do a lot of this fact finding, and there's going to be fact finding on every single one of these named assets, because Coinbase is going to need to try to establish that none of them are securities. So there's going to be a bunch of fact finding on ADA, deciding, things like down below here, the SEC has a section about expectations of possible buyers in secondary markets. Here we go. The information publicly disseminated by Cardano, IOHK, and Emergo have led ADA holders, including those who purchased ADA since March 2021. That would be when ADA started trading on Coinbase, reasonably to view ADA as an investment in and expect to profit from the efforts of the CF, IOHK, and Emergo. So, of course, Coinbase is going to deny that, because what the SEC is trying to do is establish one of the prongs of the Howey test. So this section is just about them sort of setting the parameters. What are we going to fight over? What are we going to not fight over? And it's pretty predictable between uncontested facts and the facts that establish the Howey test parameters. That's what this section does. So obviously Cardano has something at stake here. The reason why we as ADA holders or participants in the Cardano ecosystem are highly interested in what happens in this litigation is that the SEC is going to try to say that at least one of these assets is a security. Coinbase is going to try to establish that none of them are securities, including ADA. ADA, whether or not ADA is a security, is very relevant to the outcome of this case. So the ways that this can go well for Cardano are The court decides Cardano is not a security. Fantastic. Or the court disposes of this case in some other way. And Coinbase did something, like I said, they have very good counsel. And their very good counsel did something very smart. So they focused on this question, the question we brought up earlier. They say on page 7, paragraph 16, even if the SEC's construction were colorable, the major questions doctrine would require its rejection in deference to Congress's prerogative to choose for itself how to regulate a significant portion of the American economy. And here they're quoting from that West Virginia versus EPA case from last year that I mentioned to you. That was a U.S. Supreme Court case. That is because courts presume that Congress intends to make major policy decisions itself, not leave those decisions to agencies. And when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, absent clear congressional authorization, the courts will not accept an agency's novel statutory construction, even if colorable or plausible. So Coinbase's counsel is going after the right thing here. They're saying, and it makes sense to us too, even from a non-legal perspective, this makes perfect sense. The real question is, should the SEC be regulating crypto? And this major questions doctrine stands in sharp contrast with the Chevron doctrine. So Chevron tells us that the courts should give deference. If it's ambiguous what Congress intended, you should give deference to the agency in sort of laying out what it thinks, Congress intended. Major questions doctrine does not take that approach. And there's narrow and broad major questions doctrine. But at a very, very basic level, we can say that the approach is this. Courts presume that Congress intends to make major policy decisions itself, not leave those decisions to agencies. So what Coinbase's counsel is going to try to convince the court is that major questions doctrine should apply here, and Congress should decide who regulates and how they regulate crypto. So the very clever thing that Coinbase's counsel did is not including that paragraph I just showed you in their answer. It was this. This poster says, yes, Coinbase answered the SEC's complaint, but they also seek leave to file a motion asking the court for a judgment in its favor based solely on the SEC's complaint before any actual facts are developed. In other words, they ask the court to say, you win on the merits, Coinbase, based on the SEC's allegations alone. This is rare, and in my opinion, a bigger news story than the answer and forthcoming motion to dismiss. So here's the actual letter. So they're asking for leave to file a motion for judgment on the pleadings. So they're asking for permission to ask for this judgment just on the SEC's allegations. And this is super smart because this means the court can rule on this before they go through the very lengthy process of discovery. You probably realize this is high-level litigation. This kind of case could go on for years, just like the Ripple litigation. This could go on for years and years and years. And Coinbase and all of crypto could be just sort of left in limbo, barring any kind of action by Congress. And Coinbase came up with a little shortcut here. They're asking for permission to file a motion for the judge to just make a judgment on the pleadings. They're saying, hey, if nothing else, if we just isolate the SEC's complaint, can you just rule on this issue in terms of the SEC's complaint? They really lay this out down here at the bottom. They say, but there is a more fundamental problem with the SEC's case, one that the chair recognized 2 years ago and that entitles Coinbase to judgment on the pleadings now. You'll remember 2 years ago, Gary Gensler said something to the effect of, hey, we don't have authority to go after crypto. We need Congress to give us authority. Obviously, now he's gone in a different direction because he just went ahead and did it. They say the subject matter falls outside the SEC's authority. The SEC may pursue this enforcement action only if relevant transactions in the digital assets and services identified in the complaint are properly considered investment contracts and therefore securities within the meaning of the Securities Act of 1933 and the Securities Exchange Act of 34. Because as a matter of law, none of them are. The claims must be dismissed. So we're going to get this early kind of crossroads. The judge in this case is going to have to cross this this certain point where they decide early on, instead of like going through discovery and all the fact finding and then ruling on all the motions and finally, coming to a decision on this very, very central issue, the judge early on is going to have an opportunity to dispose of this case, basically. And one of the best things about this is possibly what this poster is responding with right here. Even if this court, the district court, denies this motion, even if they say, no, we don't agree, the major questions doctrine doesn't nullify the authority of the SEC in this action, this poster says, this also tees up a fast track to an appeal, even if the district court denies the motion. And the original poster here has this response in this GIF. So this is very interesting. Instead of having to go all the way through all the fact finding and the entire case, the very smart counsel for the Coinbase here has created a scenario where the judge can either dispose of the case because as a matter of law, none of them are securities. The claims must be dismissed. The court could embrace that kind of perspective and dispose of this case early, or they could say no. And then Coinbase could appeal this to the appeals court. They could go from the district court to the appeals court. And the great thing is we have the U.S. Supreme Court, who would be above the appeals court, just last year deciding West Virginia versus EPA, where they embraced this major questions doctrine. So what does all this mean for Cardano? Well, we in Cardano, we have a couple choices. We can do nothing. We can just wait and see what happens with the motion for judgment just based on the SEC complaint. And that makes a lot of sense to me as I think about it right now. It makes a lot of sense to see if the judge can just dispose of this case early, because if that happens, fantastic. We don't have to worry about the Coinbase case. We'll still have the Binance case, but there's so much more going on in the Binance case. So many additional allegations in the Binance case. That's sort of its own whole category of things. But in the Coinbase case, the judge may be able to get rid of the case early. That would be great. Maybe the judge denies that motion and it's fast-tracked into the appeals court and into the circuit court, and then we see what happens in the circuit court. Because I think even, who knows? I can't. It would be interesting to see what would happen in the appeals court, and even if it goes beyond the appeals court, then we're faced with this next step where the Supreme Court could grant cert, not grant cert. Anyways, very interesting track of events there. Either way on sort of this major questions doctrine versus Chevron deference issue. Let's say that doesn't happen. Let's say that doesn't solve the problem for us. Here's the problem. The problem is that if the case isn't disposed of early on some issue like the one I just described, eventually the court is going to have to decide, are those assets securities or are they not? Because it's pretty hard for the SEC to maintain all these securities claims if they can't show that some of these assets are securities. And the court, could easily find, a million different reasons to resolve the case without, necessarily ruling on the securities law status of Cardano. It could decide that just one of the other assets is a security and resolve the case that way, because then that's pretty much all the SEC would need to establish the things it's alleging about Coinbase. But if the court were to go all the way on this, and they decided they were going to rule on whether or not Cardano is a security, we definitely want that to go our way. It wouldn't exactly be beneficial for us in Cardano to have this ruling from this district court that ADA is a security. That's not exactly in our best interest. So the one choice is wait and do nothing, and that has a couple terminal points to it. Both this ruling on this major questions doctrine issue and maybe eventually a ruling on the actual status of ADA. We could do nothing and just wait to see how all those things pan out. Or we could file an amicus brief. This would be a friend of the court brief. This is when you're not actually a party to the litigation, which we are not. None of us in Cardano that I know of are actual parties to this litigation, unless you are involved with Coinbase somehow. You're not really a party to this litigation. It's just about Coinbase. But we can file a brief as a friend of the court. So there are a couple questions here. The first question is, should we? And maybe we should, maybe we shouldn't. Maybe it is better just to wait it out because we don't know exactly what's going to happen in this case. We don't know which way the court's going to go. Maybe we don't have to lift a finger. Maybe Coinbase, will put up such a robust defense that they take care of everything and we don't have to lift a finger. That's possible. Or maybe we should. The second set of questions is, who should file such an amicus brief? So there's a couple different perspectives on this. So the perspective that Chris O raised this morning and that I've embraced in the past is that perhaps one or more of the founding entities should consider filing a very well-constructed amicus brief here. So the other perspective is that it shouldn't be one of the founding entities, because one of the founding entities doing that might somehow contribute to the perception that we have centralization in our ecosystem. And that's a very valid point. That was raised today by Jane, and it's been raised in the past by others. I think that's a very legitimate and valid point. But at the same time, if we are going to file an amicus brief, I think we want to do what Coinbase did. I think we want the best possible counsel. And I think the best way to make that happen is if someone with very deep pockets were to arrange for such an amicus brief to be filed. If they were to fund an amicus brief like this, and I think the deepest pockets are going to end up being in those founding entities. One or more of those founding entities definitely have the deepest pockets. You could argue, of course, the next thing people are going to say, of course, is, what about Catalyst? Catalyst has very deep pockets. That's true, but the Catalyst process might be very burdensome for this kind of a thing. I mean, first of all, you've got a lot of different voices in Catalyst, and it takes some time to get through all that. And then even if you were to get some funds, you've got to select which law firm to go with. You've got to find a law firm that's going to accept ADA, right? Because Catalyst awards are in ADA. So there's a bunch of difficulties there. I mean, the kinds of law firms we might want to be counsel on an amicus brief like this maybe aren't the kinds of law firms that would want to accept ADA, right? This is kind of a difficulty. And also you get a lot of people, there's a lot of voices involved in a Catalyst proposal like this, and you'd have a lot of people saying, no, don't use this very, very expensive good firm. Use this much, much smaller firm, So there's a lot of difficulties. There's a lot of sort of administrative difficulties in raising funds through Catalyst and hiring what I think at least would be the right kind of law firm for this, because we're a very big ecosystem. There's a lot of money on the line in Cardano. Whether or not Cardano is a security is a really big matter that has a lot of economic impact, because we're a big ecosystem. I mean, we're talking about billions of ADA, 45 billion ADA that equate to billions and billions of US dollars. There's a lot of money on the line here. So I think if we were going to file an amicus brief, we want the very best counsel to very carefully construct that amicus brief for us. The second matter is whether we should be a part of an amicus brief that's filed on behalf of all holders of all of the tokens and coins named in the SEC complaint. This is sort of a separate issue. I think this is separate from, should it be a big firm? Should it be a small firm or like a one-man firm or something like that? Regardless of that, there's a question about whether or not we want to throw our lots in with all the other coins. Here's my argument why that's not optimal. Because if we throw our lots in with all the rest of the coins, the central thrust of the argument of that Amicus brief is going to be an argument that is beneficial for all the coins. Sure, there's going to be different sections about different coins, and you can try to lay out different things, to establish the scenario with each of the different coins. I'm sure that's going to happen. But the main thrust of the Amicus brief, if that council is representing all of those coin holders, the main thrust of the argument is going to be an argument about facts that apply equally to an ecosystem like Solana as they do to Cardano. There are huge factual differences between Cardano and Solana. I don't think we necessarily want to, don't necessarily want the main argument to be things that apply equally to Solana as they do to Cardano, because we didn't do a US ICO. Cardano's ICO happened in Japan. There were no US buyers. We have a lot of these really beneficial facts that distinguish our situation from that of a Solana or a lot of the other coins that were named in that SEC complaint. I think we want to distinguish ourselves from those other coins. I think we want to make the really big, potent Cardano arguments. We didn't even do a US ICO. We didn't even have US buyers in the ICO, because then the counter arguments to that Amicus brief would have to do with the secondary market, right? Because remember, the SEC only needs to show that basically one of those assets, one of those dozen or so assets, was a security. So if we're just one out of a dozen ecosystems represented in this Amicus brief, I think the arguments that are able to be made are going to be much less potent than if there's a Cardano Amicus brief that says, hey, if you want to say Cardano is a security, you need to make all of these kinds of novel arguments about secondary markets, because we never did a US ICO and we never had US buyers in the ICO. Finally, it looks like the Pavia playground is open. They say you can download the experience here. I believe this is a PC download. This uses the same tech, which will power the rest of the 100,000 land experience, but is still very much a test environment under development. Please come and join us. I'm hearing good things. If you go and check it out, let me know how everything looks. I do not have access to the requisite equipment, so I cannot join myself, but I'd love to hear. I hope you're having a great week, and I'll talk to you soon.